The hearing will now come to order. The chair recognizes himself for. The chair recognizes himself for 5 minutes for the purposes of questioning the witnesses. I'd like to start off with some very simple questions to get on the record how the witnesses review the legislation we're contemplating today. And I'll just ask each and every one of you if you would just answer with a yes or no. Answer if you can, or if you can not, then give me a very brief explanation of your vote, of your answer. Just finished voting. So my first question is, with regard to H.R. 1319, do you support the legislation in its current form? If not, do you support the intent of the bill with revisions? And my second question, you can answer both of these together. Do you support H.R. 2221 as it is currently drafted? If not, do you support the intent of the bill with some revisions? I'll start with Mrs. Harrington. Would you press the button?
The Federal Trade Commission strongly supports the intent of both bills. We would like to continue working with committee staff on revisions to each, but we're particularly supportive of the enforcement authority and tools that both bills give the FTC and civil penalty authority.
Thank you. Mr. Song.
CDT has significant reservations about H.R. 1319 as drafted, but we certainly support the intent. We do think it may be tricky to figure out the drafting details, but we're certainly happy to work with the committee on that. On H.R. 2221, we generally do support the bill as drafted. There's some modifications we've suggested, and we absolutely support the intent.
Thank you. Mr. Holloman?
I actually agree fully with Mr. Sohn's comment that we support the intent of both bills. We have some recommendations in our written testimony, believe strongly that action is needed. I think it may be more difficult to make some of the definitions in 1319, but are certainly eager to work with the committee to ensure the intent is fulfilled.
Mr. Lafferty?
I'll just speak to 1319. We absolutely support the intent of the bill, the clear, conspicuous notice, and the informed consent for very important file sharing modalities that could have major impact on consumers. We just don't think it can be legislated. We've worked hard to try to come up with suggestions for a redraft, and it's very difficult to get the language not to reach out and touch other kinds of technologies and future software applications that would be impacted and disadvantage U.S. firms from overseas competitors. So we support the intent, but not the language.
Mm-hmm. Mr. Pratt.
The CDI has no position on H.R. 1319. With regard to H.R. 2221, we certainly support the intent. We've outlined in our written testimony a range of suggestions about how we could align the bills with other federal laws, and if we could accomplish that goal, I think we'd feel more comfortable with the final work product. Thank you.
Thank you.
Mr. Chairman, we do support the intent of H.R. 2221 and generally support the legislation as drafted. We have a number of suggestions in our testimony for how to strengthen it. With respect to 1319, we don't have a position for or against the bill. With respect to the intent behind 1319, we think it may be possible to get to some of the concerns regarding security through other legislation, but we would certainly be happy to work with the committee to see how it can be accomplished.
Mr. Bobak.
Mr. Chairman, we strongly support both 2221 as well as 1319 in clearly raising awareness and providing some responsibility and structure to a very needed process both on the peer-to-peer as well as just federal data breach notification.
Mr. Chairman, I'll confine my comments to H.R. 1319. Yes, absolutely strongly support the intent of the bill. I'm aware of that there are legitimate concerns about making sure that we don't necessarily sweep in entirely, and potentially entirely legitimate uses of peer-to-peer technology. And would be happy to continue to work with the committee and anyone else to try to get to a place where everyone is comfortable.
Chair thanks the witnesses. The chair's time is concluded. The chair now recognizes Mrs. Bono Mack from California for the 5 minutes for questioning.
Thank you. I thank the chairman and our panelists also for your time today. Mr. Lafferty, I'd like to read to you a bolded warning in the user guide on the LimeWire website entitled Using LimeWire and P2P Software Safely. The warning states, I quote, "Please ensure that any folder on your computer that contains personal information is not included on your in your LimeWire library," end quote. So tell me, Mr. Lafferty, if I were to complete a default installation of LimeWire 5.1.2, what files and folders will the mere installation of the program include in my LimeWire library?
With the LimeWire 5 and later versions of LimeWire, sensitive file types, which are a large number of extensions of files to protect your spreadsheets, your Word documents, PDFs, things that might have sensitive data, are unshared by default. So I would completely refute the testimony of Tom Sidner earlier. That just isn't true. When you, in either example that he gave, with a family that kept just upgraded the version, or the one that uninstalled it and reinstalled it, in both cases, all of the sensitive file types are unshared by default. It's over. They're no longer accessed or shared. To reshare any of those files, you'd have to individually take the file and go through, ignore several warnings to put those individual files into the mode where they could be shared, and then be asked whether you want to share that with specific friends or the network at large. So LimeWire 5 has done away with the concept of shared folders, really, and now it's a file by file.
There's specific warnings. What do they say? And it is not, it's still actually sort of an inherent default. You have little boxes that come up, that I believe there are 4 different boxes that are there, and one does say My Documents. So you just said that that could be an Excel spreadsheet, which in fact would probably be saved under a My Documents folder, would it not?
If you chose to put the My Documents folder into a shared mode, it would still
Is that
unshare.
The default for an Excel spreadsheet for the standard user?
Is a I don't understand the question.
Where is a default Excel spreadsheet saved on your computer, on your hard drive? Is it not necessarily defaulted to My Documents?
It's probably different for every person, but the point is
probably different. What is the default? What is the default? Where does Mr. Sidner? Perhaps you have the answer to that. I'm happy to.
It doesn't really matter where it is. That file type won't be shared.
How could it not matter? With all due respect, how could it not matter where it is? That's the root of the whole problem here.
Because it won't be shared.
Unless you check simply one of the 4.
Unless you choose that individual file, if it has that Excel spreadsheet.
That individual file.
Individual
Mr. Sidner,
file. Correct.
Do you care to comment on that?
That's correct.
Yes, that's not quite an accurate statement about how the LimeWire My Library feature works. My Library is in LimeWire 5. In LimeWire 5, it basically are the set of documents that are going to be managed in LimeWire, and thereby that set of documents is going to be much easier to share because they are going to be in the library, and there will be a button to click to share them. Now, and that's why the LimeWire User's Guide has the warning that you read. Please ensure that any folder in your computer that contains personal information is not included in your LimeWire library. Now, by default, when you install LimeWire 5.1, and I did it last night again, the default option is to have LimeWire put all of the files stored in your My Documents folder and all of its subfolders into the LimeWire library. That alone will not share them, but it will make them available for sharing and much easier to share and therefore the behavior of the program is simply not consistent with the advice in the user's guide. As to my testimony earlier, it was quite correct. The difference, the reason I think we're getting confused is is when I say sensitive files, I mean files that would actually be sensitive to share over a network like Gnutella. So if you have a scan, for example, scans of your family medical records and tax returns, those are going to be stored in image file formats often. And those will be shared by default. LimeWire will, and if you upgrade to LimeWire 5, it will continue to share those file types if you were sharing them before. And if you install LimeWire 5 on your computer and a previous version of LimeWire has ever been there, then it will automatically begin resharing files that were shared previously. So simply installing the program can indeed resume sharing of files, even if you're installing on a version of on a computer where there's no version of LimeWire currently installed. I'm correct about that. I reran the test again this morning before the hearing.
Thank you. I know my time has expired, and I hope we have a second round. Thank you, Mr. Chairman.
The chair fully intends to have a second round. The chair now recognizes the gentleman from Georgia, Mr. Barrow, for 5 minutes.
I thank the chair. I want to try and get my arms around the inadequacy of the current situation and talk about what it is this legislation proposes to do in order to try and alter the situation for the better. Ms. Harrington, am I correct in understanding that there are very limited tools available to the FTC right now to deal with this issue, that basically the only option you've got under current law is to initiate a specific enforcement action against somebody, a fact-specific action based on a specific instance, and that basically pretty much limited to, is it injunctive proceedings? Is that about the extent of it?
That's right.
No civil penalties whatsoever?
No civil penalties.
No rulemaking authority, no prescribing of proper procedures or best practices. You just got to go after individual cases, and all you can do is tell folks to stop doing what they're doing when you prove that they've done it.
The rulemaking authority available to the Commission is under the Magnuson-Moss amendments to the FTC Act, and those are laborious and take a very long time, the procedures to use.
So what we're proposing to give the FTC under 1319 would give you all some authority you don't have right now. Let me ask you, are the civil penalties helpful to y'all in trying to bring some order to this situation?
There are two things that are helpful. Civil penalty authority is very helpful, and also to the extent that some practices in these very fact-specific situations might be injurious but neither deceptive nor unfair, then having additional statutory authority is very helpful.
Earlier on in the testimony, we heard some folks raise some issues about the international end of things. We all know we're connected to a worldwide web, and that any effective regulation of this marketplace in our country is going to involve dealings with folks who can cross the boundaries in cyberspace pretty much at will. What's your concern about, if not the extraterritoriality of the law, the extraterritorial effect of us being able to regulate this? How do you think we can address that supposed shortcoming of us attempting to regulate this on our own shores?
Well, first of all, the subcommittee was instrumental in giving the Commission additional authority under the U.S. Safe Web Act, which we use to get information about overseas targets and to enlist help from other governments, and that's very useful. But that said, if there are overseas software providers who are making available file sharing software that is injurious to U.S. consumers, we can certainly assert our jurisdiction over those practices that occur within the United States, but we may not be able to reach their purveyors if they're in other countries, and particularly in countries that aren't particularly interested in helping out. One of the things that we're very concerned about is that the dominant players in this industry, which are in the United States, do the best thing and the right thing. And we think that setting some legislative standards, such as the ones that are set forth in the bill, would really help. We want the U.S. players to be the best players so that they continue to be the dominant players and the ones that consumers can use with some confidence.
The impression I get from what you're saying, and this is how I hear what you're saying, is that if we police the marketplace where everybody shops, we don't have to worry about the marketplaces where very few people shop or hardly anybody goes. Is that a fair way of putting it?
Well, we certainly should police the marketplace where everybody stops if that marketplace is subject to our jurisdiction.
But the high volume users, the ones who got the lion's share of the market, if we can make sure that what they're doing is right and appropriate, and folks who trade at these places will not have to worry about losing their stuff. We don't have to worry quite so much about those areas that might be hard to reach. Why strain at a gnat and swallow an elephant in the process?
That is certainly the intention. There is always a risk that overseas operators can gain in market share in the United States by doing, by gaining some sort of competitive advantage over the regulated entities in our marketplace. But that's not a worry right now that's keeping me awake at night.
Thank you. I'll wait for a second now, Mr. Chairman. Thank you, ma'am.
Thank you. The chair now recognizes the gentleman from Louisiana, Mr. Scalise, for 5 minutes.
Thank you, Mr. Chairman. Really kind of open this up to the whole panel on H.R. 1319. Do you think this will help prevent illegal use of peer-to-peer software, including stealing personal records, copyright violations, and things like sharing child pornography? You can just go down.
I think it'll help under some circumstances, and under others we need more. The data security bill actually could be very helpful here too, because as I mentioned in my oral statement, there are really 3 scenarios where sensitive information is shared. One is when consumers don't know, don't understand, and this bill will hopefully would go a long way, I think, there. It's not going to help when the problem is malware. And it's not going to help when the problem is a business that has not prohibited and barred from its system and its computers file sharing software. And it's not going to help if the problem is that an employee of a company takes sensitive information home and puts it on his or her computer, and that computer has file sharing software or malware on it that extracts that. So it's going to go a long way to help in scenario 1.
Anybody else want to touch on that?
Yeah, I'll just say I do think the intent and the focus of the bill is certainly on the inadvertent disclosure, so that the privacy-related concerns. I think that would be the main impact and is the main thrust of the bill.
Let me ask about the data breaches that have occurred. I think FTC had dealt with the largest one I've seen, the TJX, which I think initial estimates were about 45 million Visa, MasterCard records were breached. Ultimately, it turned out somewhere closer to 100 million were breached, and y'all had brought charges against them and subsequently other companies. Is there now an industry standard for data protection? What's your feeling on where we are today versus some of those cases a few years ago?
Well, there are certainly established good practices that in the cases that we've brought were not followed. For example, downloading available patches, preventing against well-known attacks and kinds of attacks are well settled. Necessary practices. They're not even best practices. They're necessary. And those companies did not follow those practices.
Anybody else want to add anything to that? We're getting into now an area of moving towards electronic medical records. There was some funding and language in the stimulus bill to start going down that road more as people's health information gets put on the web more and more. What kind of protections are there today? What kind do we need, whether it's in either these 2 bills or in other vehicles, to protect people's health records as they become available on the internet so that they're only available to the doctors who need to be reviewing them?
Well, the Recovery Act also directed both the FTC and the Department of Health and Human Services to do rulemaking to set standards for breach notification when consumers' sensitive health information is placed at risk. The FTC, as I mentioned, has just issued a proposed rule dealing with personal health records and other non-HIPAA covered entities that may have this sensitive information to set breach notification standards. And we're continuing also to work with HHS to do a report that is due back to Congress in a year on these issues.
Any of y'all doing any work on that issue, Mr. Bobart?
I'd like to also comment on that. There are no standards as far as peer-to-peer notifications. There are no standards as far as peer-to-peer security measures. In fact, most companies don't even have any standards on peer-to-peer. When asked, most corporations, large and small, what information they're doing about peer-to-peer, most people, if they respond at all, will say that they are blocking peer-to-peer and that they have a policy against it. That's the extent of it. And I will tell you that, or they'll say that they have a firewall or an encryption, of which nothing. Firewall does not stop peer-to-peer. Encryption does not stop peer-to-peer. Intrusion prevention, intrusion detection, and all the standard security measures do not stop peer-to-peer disclosures from happening, which is why in the past 60 days we've had over, almost 4 million disclosures of this type via peer-to-peer, because there's just no standards.
And finally, Mr. Holliman.
Mr. Splice, we believe that the incentives that are in Chairman Rush's bill that would encourage a marketplace to grow for companies who hold sensitive data to use proper security technologies to make that information inaccessible to anyone who might actually breach it, that those market-based incentives is a great supplement to the enforcement authority that the bill would give. So we think the two in together can be effective.
Thanks. I yield back, Mr. Chairman.
The chair intends to engage the members of the committee in a second round of questioning, and we'll allow each member an additional 2 minutes for the second round of questioning. The chair recognizes himself now for the second round and allocates 2 minutes for the purposes of questioning. Mr. Rothenberg and Mr. Song, is the definition of, quote, personal information under H.R. 2221, is it adequate in terms of data security? The bill only addresses financial information. Should we also consider requiring companies to secure sensitive information, such as medical information or passport numbers or et cetera? I mean, should we expand the definition of personal information?
Well, the bill has several different components, and I think for purposes of the breach notification component, the definition there is fairly close to what's been done in a lot of the states, and it reflects a lot of what's been common in the data breach notification area. I think for purposes of something like security standards, asking companies to have reasonable procedures in place to protect data, there's no reason to restrict it to the rather narrow set of data that's in the definition of personal information now, because what's currently in the bill only applies if it's not just name and address and some other information that would be enough. There actually has to be either a social security number or a financial account number plus password or a driver's license number, something like that. So I do think that the bill might consider using a broader definition of personal information for some purposes and the narrower definition for others.
Yeah. Mr. Chairman, in my written statement, I made a suggestion on this issue of personal information. I do think it's appropriate to have a broader standard and also to recognize that some of the personal identifiers nowadays aren't just limited, for example, to a social security number, or driver's license number. There are other types of personal identifiers like a Facebook member number or even the IP address associated with your computer that needs to be incorporated as well. So I think those changes can be made both to get to more circumstances where the bill should reach and also new types of identifiers.
Chair thanks the witnesses. Now the chair recognizes the gentlelady from California for 2 minutes for additional questions.
I thank the chair for the second round. Mr. Holliman, you testified that the P2P bill would cover more than just the illegitimate purpose software. You identified a number of legitimate uses of P2P software, such as bicoastal collaboration on projects. I think you actually mentioned Palm Springs to Chicago airports collaborating. So this is, of course, when used correctly, beneficial use of P2P software. So we all agree that this technology can be extremely helpful, but if such programs are covered by H.R. 13, what is the harm? How is notice and consent an issue? Back to the Palm Springs, Chicago, I think, yeah, I could see them collaborating on plans, but I don't think they necessarily want to collaborate on payroll numbers, the like. So how is notice and consent an issue in this case?
Ms. Bonovac, our sense is that there is a rapid growth in the legitimate uses of P2P, and that it will become a de facto part of how we use technology that most people will want to use. So our sense is as that part of the market grows, we want to ensure that the legislation doesn't overreach to get into things which all of us would generally agree would not necessarily need. I mean, an initial notice that that's there is fine, but the process of how you would then disable that needs to be clarified.
Which is growing faster, illegitimate or legitimate uses? I
think our sense as technologists is, and I'm not a technologist, I play one on TV, but not as technologists, but our engineers in our companies believe that the legitimate purposes of peer-to-peer in the next 10 years will certainly grow much faster than the illegitimate.
In the next 10 years, quickly in 10 seconds, Mr. Boback, which has grown faster, legitimate or illegitimate uses?
I would tell you that legitimate uses are now emerging. So while there's still a growth at this point because the awareness is still decreased and there's not enough awareness as to the problem, the legitimate uses and the distribution content is an absolute must going forward. So I am a supporter of peer-to-peer. However, the security measures, just as in the early stages of the World Wide Web, need to be addressed as in your Bill 1319.
Thank you.
The chair now recognizes the gentleman from Georgia.
I thank the chair. I think Ms. Bono-Mack is getting to the heart of the issue on the peer-to-peer legislation. If I could reframe the issue, we want to fix what's broke with this system. There is stuff out there that's inside this legislation's definition of peer-to-peer file sharing program that is malicious. There is stuff out there that's inside this definition that is perfectly benign. Mr. Holliman and Mr. Sohn, I'm going to pitch this one in y'all's direction. How would y'all define what we're getting at in such a way as to stop the bad stuff and allow all the other stuff to continue without having to have a proliferation of warnings and opt-outs that basically hobble this technology before it can even get started? Who wants to take a shot at how you would define this in order to be able to reach the stuff we want to reach?
I'll start on that, Mr. Barrow. In our testimony, we've actually listed 5 ways in which we would modify the definition in the bill and believe that if those types of changes are made, that would be useful and would help it preserve the intent of the bill, including looking at the type of purposes that the peer-to-peer file sharing program is typically used for, going at many of those things like copyright infringements, which are a huge source of concern to.
Is that an effective way of defining it, though, so that the regulators can get at what's going on, and so the technology?
Sure. We actually think that the regulators would their hand would be strengthened by more precision in the definition rather than the breadth that's in there currently.
Mr. Sohn, what do you think?
I also set forth in my testimony some ideas on that point of how you might make this more narrow and apply to what we think of as file sharing software. I agree with Mr. Lafferty's testimony that the key here really isn't peer-to-peer. Peer-to-peer is a kind of architecture. It's really about file sharing functions that could enable documents and other kinds of files on a user's local computer to be made available to third parties in bulk, and third parties that haven't been selected or aren't even known to the user. And so we proposed 4 bullet points of items that we think could be in a definition, but it tends to focus on that, the ability to share files with unknown parties with no intervening action or knowledge or selection by the user in terms of who that file will be shared with.
Mr. Chairman, my time has expired, but I'd like to ask the witness to go beyond that and actually be prepared to work with counsel on our staff to see if we can actually come up with some concrete language to accomplish this. Thank you. I yield the mic.
The chair now recognizes the gentleman from Louisiana for an additional 2 minutes.
Thank you again, Mr. Chairman. This might not necessarily be these 2 bills might not be the vehicles for it, but they might. It's been a problem for years, especially with identity theft getting worse. With so many documents and authenticators that use Social Security numbers, that require Social Security numbers to be used, or documents that are public record that still require people to use Social Security numbers. A number of states have gone on their own and tried to ferret those out and prohibit Social Security numbers on public documents, but it's not universal. There is no real standard still. I think there was standalone legislation, might have been in the last Congress, that really didn't go anywhere. But is there a way that we can have some kind of standard to protect people's Social Security numbers so that they're not required for certain documents or authenticators, so that they're not so easily obtainable by third parties that are trying to take them for bad purposes? Kind of open it up, start off with Ms. Harrington and anybody else that wants to take a shot.
Well, as part of the President's Identity Theft Task Force work that we've been engaged in, there are a couple of important initiatives that we're supporting. One, the task force brought about a government-wide examination of government uses of Social Security numbers with the goal of minimizing to circumstances where the number is absolutely essential. Federal government agencies' use of Social Security numbers, and I think a lot of progress has been made in the government on that. Number two, the FTC, as part of the Identity Theft Task Force work, convened a workshop and has continued to work on the question of authentication and how better authentication procedures and technologies can be developed so that something like the ubiquitous Social Security number is no longer needed. But there are lots of commercial settings where both, right now, where both consumers and businesses benefit from the use of Social Security numbers and may need them. And until we have much better authentication measures available, it's a very tough question to answer, what to use instead of Social Security numbers. For example, consumers have really benefited in many instances from being able to quickly get a loan to get a car. That whole credit reporting system depends on Social Security numbers, and we need a replacement, but we don't have one yet.
And at least in the government sector, where we can set up a mechanism where people aren't required to have it on a document that's public record, because clearly in the government arena there are records that are public, and some of those records require a Social Security number, which obviously poses big security breach problems that have been documented. So if there's a way in this legislation, if there's a way to maybe try to address that, I don't want to interfere with the chairman or Ms. Bono Mac's bill, but if there's a way we can do something that doesn't necessarily cause other problems on the other side, where we can try to address a narrow part of that problem. Thank you.
The chair really just want to again thank the witnesses. We've imposed on your time pretty significantly this afternoon, and you certainly are appreciative. We are appreciative of the fact that you allowed us to do that, and you've been a great panel, and we want to make sure that if you'd be so kind, we want to keep the record open for at least 72 hours. And so there might be members of the committee, a subcommittee, who will in writing ask questions, and if you would respond in writing within 72 hours, the chair would certainly appreciate that. So thank you so very much again, and you've really done this subcommittee quite a great service. Thank you. The hearing is now stands adjourned.